Chair. I'm the hearing officer for this Sustainable Land Development Code, and I'm calling today's meeting to order. There are 3 matters to be heard today, and I just would ask staff to confirm whether there are any additions or deletions to this agenda.
Hearing Officer Aber, I believe Dominic Cisneros, the supervisor, will address those comments.
Okay, Mr. Cisneros, are there any additions or deletions?
Good afternoon, Hearing Officer Aber. Item C on the agenda, there was an addition to the report with some language, as well as some language added to condition number 2. And we also added an additional letter of opposition on Exhibit I and added an extra Exhibit K to prove the legal lot of record.
So that was an additional, an addition to the conditions that staff is recommending, and an additional letter in opposition. And what was the third?
And the third was Exhibit K was added, proving legal lot of record.
Exhibit K. Thank you. And that is the Montoya density variance case. Is that correct?
Hearing Officer Aber, yes, that is correct.
At this time, I would call case number 245170, Angelo Abeta, applicant.
Thank you, Madam Hearing Officer Aber. Jessica Gonzalez, Building and Development Review Specialist Senior. Angelo Abeta, applicant. Summer Carnes and Associate LLP, Carl Summers, agent. Request a variance of Chapter 8, Table 8-5, Dimensional Standards, Agriculture Ranching to create a 2-lot residential subdivision of a parcel of land consisting of 2 acres and a 6-acre lot. The subject property lies within the agricultural ranching zoning district, which allows for 1 single-family residence per 160 acres. The property is located at 0 Ojo de la Vaca, Commission District 3. The applicant is requesting a density variance on an existing 6-acre parcel and 2-acre parcel. This variance request is being made to allow a 2 residential subdivision of a parcel of land consisting of 2 acres and a 6-acre lot. The existing 6-acre parcel and 2-acre parcel are zoned agriculture ranch, illustrating the allowed density at 1 dwelling units per 160 acres. The applicant has addressed the variance criteria and staff has responded to the applicant's comments. Building and Development Services staff reviewed the variance application for compliance with pertinent SLDC requirements and found that the facts presented do not support the request for a variance to allow a 6-acre lot and a 2-acre lot to be recognized as a legal lot of record. Staff's recommendation is for denial of the request for a variance of density to create a 2-lot residential subdivision of a parcel of land consisting of 2 acres and 6-acre lot. The subject property lies within the agricultural ranch zoning district, which allows for 1 single-family residence per 160 acres. The deeds were started prior to 1981, but was not completed to be recognized as legal non-conforming. If the hearing officer finds the variance criteria has been met and recommends approval of the variance, staff recommends the following conditions be imposed. Madam Hearing Officer Aber, may I enter these conditions into the record?
Yes, please, Ms. Gonzalez.
Thank you. This report and exhibits listed below are hereby submitted as part of the hearing record. Staff requests the hearing officer memorialize findings of fact and conclusions of law in a written recommended order. The Santa Fe County Planning Commission may hold a public hearing on this matter on November 21st, 2024. Thank you. At this time, I stand for any questions.
Ms. Gonzalez, I just have a few questions. I'm looking at the 3rd page of your report. The 4th page of your report. And the second staff response on that page. it begins, the SLDC establishes zoning and density requirements. Do you see that paragraph?
I think let me pull it up on here. I think my numbering is off on my Perkins report. Madam Hearing Officer Aber, I did find what you're
And that,
looking at.
and that staff response continues. The applicant would be allowed to have a dwelling unit on a 6 and 8 acre lot. Is that just a typo and it should be on a 6 and 2 acre lot?
Hearing Officer Aber, that is a typo.
Okay. Zoning code that was in effect at the time of the creation in 1986 of these lots. At that time, was this property also zoned agricultural?
Hearing Officer Aber, I am not sure if this property was zoned agricultural prior to 1981.
Here in Ossaber, before 81, there was no zoning in the county. So
Right.
the zoning would have started in 81, and it was probably homestead agricultural at the time.
Well, I've got the 1981 ordinance that establishes the first Santa Fe County zoning, and it breaks it down to metropolitan area and agricultural area, and then that's further divided between the Estancia Valley and then the Northern Valley agricultural areas. And I'm assuming this would be of those two, it would be the
Yes, it would be an
Estancia.
agricultural area.
In the Estancia agricultural. And just for the record, it goes on to state that the lot sizes shall be 50 acres for the basin fringe and 10 acres for the basin zone. So it appears that even under the 1981 code, the 6 acre and the 2 acre would not be adequate.
That is correct.
Thank you. Thank you, Ms. Gonzalez.
Thank you, Hearing Officer Aber.
Good afternoon, Madam Hearing Officer. My name is Carl Summer. My mailing address is Post Office Box 2476, Santa Fe, New Mexico 87504. I do.
Oh, thank you.
Madam Chair, I gave staff a copy and I gave the recorder a copy for the record. I'm here on behalf of the applicants, Angelo Abeyta and Mr. Henry Duran. Madam Hearing Officer?
I'm going to interrupt you for just one second.
Sure.
We have an exhibit issue. For the court reporter, the exhibits are numbered from staff or also numbered alphabetically. And then the ones that Mr. Summer just presented are also alphabetically. So I guess it could be staff's Exhibit A and then the Exhibit A. Okay, thank you.
I apologize for the confusion that created. This case is a bit like the story of what created a white elephant. In India, when the king gifted a white elephant, a sacred animal, to somebody, it became the obligation of that person to maintain that white elephant for the remainder of its life. And that's where the term white elephant comes from, that a gift can sometimes be a burden. In this case, Mr. Duran and Mr. Abeyta have inherited a problem that needs to be resolved. And the exhibits that I've given you, the first Exhibit A is a picture that really sums up what happened in the history of this property. So in the applicant's Exhibit A, for the record, you'll see a red box, and that is an 80-acre piece of property that Rosendita Abeyta obtained from her husband and herself. And Exhibit B is the deed by which that 80 acres was obtained. And that was in 1975, and it created an 80-acre parcel before there was any code. The yellow is the 8 acres that was divided by a partition lawsuit, a quiet title lawsuit that ended up in a judgment. And then the dark blue and light blue are the 6 and 2 acre parcels within that 8 acres. I hope that helps you graphically see what we're talking about here. Rosendita got the property from her husband in 1975. She filed a quiet title action because the title was not clear. That quiet title action resulted in a final decree. That decree is Exhibit C, and if the hearing officer would turn to, there are not numbered pages, unfortunately, in this decree. It is the 3rd full page, actually the 2nd page at the bottom, says, plaintiff shall grant by warranty deed to Maida Duran and Martha Jones, they were sisters and they were the daughters of Rosendita, an 8 acre parcel. So out of that 8 acres, the court divided this property into the 72 and 8. That was a legal division under the code at that time. So the 8 acre parcel was a proper division. The 2 sisters then divided the property by exchanging deeds in satisfaction of the debt that one owed the other for attorney's fees that were incurred in that quiet title. So 75, the 80 acre parcel is created. In 80, the quiet title, mind you, is filed before the code was enacted. It was filed in 79. If you look at the first page of that quiet title, it's a 79 date. That took whatever number of years, it took 7 years to resolve. The resolution was another division, which under the code by court partition would have created a legal 8 acres. So if nothing more had happened, we wouldn't be here. Martha and Maida were sisters. This property was inherited down through those 2 families to Henry and Angelo. And the deeds that you see on exhibit, I put in there Exhibit D because Exhibit D shows that the remaining 72 acres was sold by Rosendita to Mr. Lynch on a real estate contract. So the surrounding property was sold pursuant to a real estate contract to Mr. Lynch and his family. The very next deed, the Exhibit E, is the deed out in accordance with the partition lawsuit from Rosendita to Martha and Maida. That was the deed that followed the partition. The next set of deeds, Exhibit F, these are the divisions of the property that resulted today.
Those are the 1986.
Yeah, this happens all after the quiet title is finished, and I submit to you it couldn't have been done before that judgment was entered. But we do have, and we submit an illegal division of an 8 acre parcel into 6 and 2. Where does that leave us here? You have Mr. Abeta, who is disabled and lives in California. He has no other assets but this asset in his life. He's a man, I think he's older than I am. I'm 63. I think he's 67 or 68. I'm not sure. He inherited this from his grandmother, who was Martha. Henry got this from his mother, his mother, Martha, through her estate. And those deeds are shown. What we would have is, under the code today, is a person would be able to build a house and an accessory dwelling on this 8 acres. What we're asking is that Mr. Abeta and Mr. Duran, they have separate properties. They're cousins, but they live, they don't, their joint ownership is not, I would say it's not copacetic. These are not people who get along. And there is no way to go to court today and partition this property under the code. Staff has said to you that if you find that the recognition of these 2 lots is allowed under as a variance, They have imposed a condition that no accessory dwelling units be allowed on either lot. We are in agreement with that condition because what that ensures is that nothing more would happen on this 8 acres than would have happened under the code today. So if Mr. Duran and Mr. Abeta came in as joint owners of 8 acres, they could put a house and an accessory dwelling unit on the 8 acres. If we divide the property, and with the conditions that staff has suggested, we'll end up in that same place. The hardship for these two individuals is they inherited this problem. As I started out, they got kind of a white elephant, and now they have to deal with it. The only way for them to deal with it is to request a variance so that they can use the property in some fashion. And the condition that staff has suggested, if the hearing officer sees fit to grant the variance, is appropriate, and it would not intensify the development that would otherwise happen today under the code. I submit to you, many people come before you and they ask for variances to density because they have kids or they have this hardship or another, and that hardship is often created by their desires. In this instance, this was not created by either applicant here, Mr. Duran or Mr. Abeta. It was created as a result of a partition that took too long to get finalized, and they inherited this problem. So it's not something they created and coming to you saying, hey, well, help us out of the problem we created. I submit to you that that's an important factor. In many variance requests to density, you get situations where people divided the property and they come before you and say, well, we divided the property illegally, please recognize it. That's not the case here. These two did not divide the property, it was divided earlier.
Mr. Summers, could I interrupt you?
Sure.
I didn't see any mention of this further quitclaim division of the 8 acres into 6 and 2 in Judge Encinius's order.
Correct, and that's why it's illegal.
Right.
That 6 and 2 is the illegal division, and it was between the two sisters to settle who
Right.
owed the legal fees.
Okay. I have a question similar to what I asked staff, and that is, on your letter dated July 25th, in the second paragraph, mid-paragraph, it begins, in pre-code quiet title, a final decree was entered December 7th, 1985, which final decree divided the 80-acre tract into 2 tracts. A 78-acre tract, which
That's a
Rosendita Abeta retained, and an 8-acre tract.
That's a
that was changed.
typographical
So
error.
that should have been
Yes.
72.
Yes,
Okay.
you're right, correct. I'm sorry about that.
Just trying to get all these numbers right.
And then I tricked staff into making the same error.
Okay, is there anything else you wanted to add? to
I
this?
didn't, I just submit to you that this is a unique circumstance created by a division decades ago that these two individuals have inherited. And the condition that is suggested would preserve what the code would otherwise allow today. 2 dwelling units on this 8 acres, one being an accessory and the other not being, but you wouldn't have an increase in density beyond what the code would otherwise allow today. And I would stand for any other questions you might have.
Okay, thank you. I don't have any other questions. Does staff have any questions for Mr. Summers? Does staff have any comments regarding his presentation? And has staff received any comments on this application, either for or against?
Hearing Officer Aber, I did not receive any comments from anybody.
Okay, thank you. And I can't tell, but is there anyone online that is commenting on this case?
Hearing Officer Aber, there's nobody that is raising their hand to speak on this case.
Okay, thank you. Well, with that, I will take this case under consideration, and I have a recommended order within 15 business days. You're welcome. The next case today is case number 245190. Matthew Sanchez applicant request a variance of the slope disturbance for roads and driveways.
Thank you, Madam Abear. Destiny Romero, Building and Development Review Specialist. Madam Abear, before I begin, I would like to let you know that what Dominic Cisneros is handing you out is an additional exhibit, which is Exhibit H, Proof of Permitting. And also, in my report, I would like to change Section 7.17.10.4.1 to Section 7.17.4.3, no build areas. That-
Excuse me, let me find that.
No worries.
And that's in your report, right?
Yes, ma'am.
On what page?
The beginning under issue, where it says Chapter 7,
Oh, okay.
it should be Section 7.17.4.3, no build areas.
7.17.4.3.
0.4.3.
Okay, no build. Thank you.
Thank you, Madam Abear. Matthew Sanchez, applicant, requests a variance of Chapter 7, Section 7.17.4.3, no build areas. The property is within the traditional community zoning district. The site is located at 43A Ojito Drive within Township 20 North, Range 9 East, Section 20, Commission District 1. The applicant met with staff to submit his setback variance on August 5th, 2024. The applicant is requesting a variance of Chapter 7, Section 7.17.4.3. The applicant states that he received a grading permit February 25th, 2013, with no knowledge of the permit expiring. The applicant received a notice of violation from Santa Fe County Code Enforcement on April 4th, 2024. The notice of violation was issued for no development permit, terrain management, and was issued a stop work order. The applicant states that he graded 1,200 square feet of 30% or more slope disturbance. Applicant has a revegetation plan which includes reseeding, fiber, wattle rolls, and installation of a retention pond. The applicant has addressed the variance criteria, and staff has responded to the applicant's comments as contained in the memo. Building and Development Services staff has reviewed this request for compliance with pertinent SLDC requirements and has found that the facts presented do not support the request for a variance. The use may impact adjacent land uses. No extraordinary and exceptional conditions of the land exist. Staff recommends denial of the request for a variance of 30% disturbance of slopes, Chapter 7, Section 7.17.4.3. There are alternative buildable areas on the property that contain 0 to 15% slope. If the hearing officer finds the variance criteria has been met and recommends approval of the variance, staff recommends the following conditions be imposed. Madam Abear, may I enter the conditions into the record?
Yes, please.
Thank you. I stand for any questions.
From looking at the photos that you had attached as exhibits, it appears that some work has been done on this grading. Is that the case?
On the only work that has been done to the property was the 30% grading that has been done. If you're seeing a residence in the pictures, that's the background of another property.
Okay, so this grading is strictly for a road, a driveway?
It was for buildable area.
Oh, it is for a buildable area?
Yes, ma'am.
So the exception that I see under 7.17.10.4, there's exception number 2, which talks about isolated occurrences of up to 1,000 square feet. That only applies to the roads and driveways. Is that your
That's
understanding?
correct, Madam Abear. That is why I asked if I could change the section to Section 7.17.4.3.
And that is the only work that's been done, is what appears in these photographs? That-
Yes, ma'am, that is correct.
And I believe you testified that there are other buildable sites on that property, is that correct?
Yes, ma'am.
So it appears that this permit was back from 2013, and at that time, it was a permit to do grading with clean fill. So how does what he has done at that property deviate from the requirements of the code?
Madam Aber, if you look at page number 2 of Exhibit H under proof of permitting,
Yes.
we did make some notes on the approved survey that was submitted for that permit, and we put where the area of grading work that was approved via permit number 2013-69, and then we put approximately the location where the applicant graded without a permit. So the permit that he received and where he graded were two completely different areas.
Do you know whether there's any disturbance on the area that was, where it was approved and supposed to be done? Was there any grading there?
No, ma'am. There was not any disturbed to where he was
So
approved.
the disturbance is just to this corner that's circled? Is that
Yes, ma'am,
correct?
that is correct.
Okay. And have you received any opposition, letters in opposition to this, or letters in support?
No, ma'am, I received no comments from any of the neighbors.
Okay, thank you very much.
Thank you, Madam Aber.
Mr. Sanchez?
Good afternoon, everyone. Madam Hearing Officer.
Just a moment.
Yes, ma'am. My name is Matthew R. Sanchez. I'm a resident of 49 Ojito Drive, which is located in the traditional community, Ojito Estates, which is located by half an hour north of Santa Fe. I've been a resident of Santa Fe County for all my life. I want to start off, Madam Hearing Officer Hebert, it is correct that I did request a development permit in 2013. At that point in time, I was unaware of a requirement, or it was not disclosed to me that there was a 30% disturbance requirement that you could not do. My understanding with communications between the hearing officer, Mr. Joseph Martinez, who represents Santa Fe County, and other individuals within Santa Fe County, that the 30% disturbance was incorporated in the Land Conservation Handbook, which was dated December 16, 2016. So prior to that, my understanding, and I'm not for sure on this, but they communicated to me that that 30% slope disturbance was in multiple documents prior to, what was never specifically defined until 2016. So when I got that permit in 2013, I was unaware of that. And when I was issued the notice of violation, I was given what you call GIS slope analysis map. This is something I never seen before. This is a map that clearly states it's a color-coded map within Santa Fe County that has red, yellow, and orange. This particular site was identified as a red area here. One of the questions that I asked, is this readily available to the public and/or Santa Fe residents? And the answer to that is no, it's not readily available. So I asked the Santa Fe County representative, how was I supposed to know that I was in violation? Okay. In the past, looking at the maps itself, there's multiple structures, multiple dwellings that have already set a precedence that they've disturbed a 30% grade. I also asked the question due to the fact that on the development permit, there's no expiration date. Okay? My son's building a house right next to this particular lot right now. The development permit is practically identical from 14 years ago. There's no expiration date. This is a recommendation that when I met with the technical committee earlier this year. I did recommend that as a Santa Fe resident that we impose something that way there's no argument or miscommunication of when it expires. And I'm not sure, correct me if I'm wrong, Mr. Cisneros, did that get implemented? Or is it in plans of being implemented?
So, Madam Hearing Officer Abear, when an applicant picks up their application or their actual permit, typically the staff member will identify that the expiration date of a permit is 1 year to begin and 1 year to finish for a total of 2 years. We do not have that noted on any documentation currently with any in-person submittals, but that is something that we're implementing with our online permitting system.
Thank you, Mr. Cisneros. Mr. Sanchez, as I understand it, when you made this permit application in 2013, it wasn't, as I thought initially, for a road. It is actually for a residence, is that correct?
It was to level an area, yes, ma'am, for a dwelling.
For a dwelling?
Yes,
Okay.
ma'am.
I just wanted to make sure I had that.
Madam Hearing Officer Abear, I have multiple parcels within Santa Fe County as well as throughout New Mexico. This particular piece of property was in the process of getting a family lot split. This particular property was going to be for my daughter to construct a house. My son's in the process of doing that as well, which is right next door. Prior to coming to this hearing, I did meet with every homeowner within that subdivision, within 500 feet of this particular impacted area. And I do have signed signatures with dates indicating that they have no problem with what I've done or what I plan to do in the future. I did not proceed with the family lot split due to the fact that I was given a notice of violation and I want to get this completed and fixed for us to go forward. I did do my due diligence as far as getting the permit. I might have been not in a timely fashion of doing the leveling itself. I'm not here to, I made some assumptions. Obviously, they were incorrect. I want to correct the issues that we have here. When it was identified, I did a vegetation plan. I've had the area furrowed, which is a form of reducing any type of velocity of water from any type of runoff from the hillside itself. I have plans on making a retention pond. One of the considerations that I also took into play is that in Santa Fe County, you have, and as part of this is a part of an HOA community, there's mandatory setbacks from every property line, which is 30 feet. And then you also got to take into consideration that you also have wells and septic tanks from the surrounding residents. So when there's particular distances that I need to keep away from, whether I dig a well or put a septic. I also was granted this year a well permit from the state engineer's office, which I had to get a development permit as well. I did get approved and get authorized to drill a well on this particular piece of property. Another note, the majority of the property downslope, myself or my family own. I'm just here to plead my case that I'm requesting this variance. I was unaware of that 30% slope disturbance. If I was aware of that, I would have not disturbed that piece of property. But on the other note, I am very concerned that this information is not readily available to the public. Another concern I have for several years, approximately 12 years as I've owned this property, I've been paying Santa Fe County property taxes, and I was unaware that some of these pieces of parcels that I own have unusable building sites. And another point I want to bring out, what if I was to have sold that property to someone else? And I was unaware of that. They come into Santa Fe County office and request a disturbance permit, and then they find out it's a non-buildable site. I mean, this is the catch-22 where I think we can do a better job within Santa Fe County to support not only present and future residents, to help them have a win-win situation across the board, due to the fact that if I was to have sold this property and they would have came to get a building permit, they would have been told that they cannot build on that site. And I asked the question, how do people know this? And I mean, the response I got is a lot of times they work with the local real estate agents. And I mean, that's a catch-22, whether that real estate agent shares that information with them or not. So I'm here to plead my case. I'm a family man. I'm here to try to help my family. The whole purpose of this development was to give it to my daughter so she can build a house. I'm not a man of a lot of money. I'm a military veteran, just trying to dot my I's and cross my T's.
Mr. Sanchez, approximately how much it states in the staff report that it's about 1,200 square feet that has been disturbed on this slope.
That is correct.
And there are other building, apparently, sites that would conform with the code.
So when we mention other building sites, if I would have, where this 30% slope was, I would have had drainage issues if I would have placed the house down at the bottom. Not only if I would have done that, I would have had to have dealt with the wells and septic surrounding that area, which limited my space. I could build the house, as well as the 30-foot setback that's already documented in Santa Fe County under the HOA requirements. So right off the bat, I'm struggling with the 30-foot boundary all over that particular lot, and then struggling with making sure that I put the well and the septic in the court accordingly, so I don't violate any type of environmental requirements.
And is this a 2.5 acre lot? Is that?
This particular lot was in the process of getting a family lot split. It's currently 5 acres. I have several children, which I had planned on giving 2.5 acres each one of my children.
So this is a 2.5 acre lot?
Yes, ma'am.
That you're talking about? Is there anything else you want to add, Mr. Sanchez?
I just want to, for the record, I've worked exceptionally well with the staff of Santa Fe County, treated them up with the utmost respect. I've been engaged. At the end of the day, this has caused me a lot of stress, a lot of sleepless nights. I'm what you consider a worry wart. I worry about everything. This is something that I feel that I hope that this committee and your hearing officers support as far as going forward. I think that's all I have.
Thank you very much.
Thank you,
Ms.
Madam.
Romero, Ms. Romero, could I ask you another question about the other building sites? Did staff take into consideration what you just heard Mr. Sanchez testify to, as so far as the placement of the septic and the well and the drainage issues because of the slopes?
Madam Aber, yes, we did.
And you still believe that there is at least one buildable site that wouldn't be affected by the drainage issues?
Yes, ma'am. There's at least one buildable site that he would be able to build that would have disturbed less than the 30% slope.
All right, thank you.
Hearing Officer Aber, for clarification, Santa Fe County does meet with the Association of Realtors and Local Homeowners Builders Association to get the word out of, prior to them submitting for permit, this is the necessities that are required. As far as our ordinance, terrain management regulations came in place in 1996 and have not changed much. They're pretty much basically the same. Mr. Sanchez has a buildable area that was lower in the area, and that's where he initially applied for the permit. He is correct. There is no expiration date, as Mr. Cisneros has indicated in his statement. That's something county staff is working on. We also have coming forth our online permitting, which is going to allow links to various codes to identify areas that are enabling for some constituents. So we are working on some of the process, but I just want to make some clarifications there.
Well, thank you. And the 30% disturbance, you're saying it existed prior to the 2016 code enactment, is that correct?
Hearing Officer Aber, that is correct. In 1996, the terrain management regulations were in place, and this was one of the areas within that section of the ordinance.
Thank you. Yes, Mr.
Madam Hearing Officer, one thing I want to note, I'm very familiar with LiDAR, ground penetrating radar, and the latest technologies when you're doing out site topographical layouts. LiDAR is not 100% accurate, so it could be 30%, it could have been 25%, it could have been 20%. At this point in time, I had already leveled, so we can't go back and determine what exactly, from an accurate standpoint, what that slope was.
I see. Okay, thank you. Thank you for the information. Is there anyone in this room that wants to comment on this case? Is there anyone online that wants to comment on this case?
Here in Officer Aber, there's nobody online raising their hand to talk.
Thank you. Thank you very much.
Thank
Mr.
you, Madam
Sanchez.
Hearing Officer.
The last case on the agenda today is case number 245120, Annette Montoya density variance.
Thank you, Madam Hearing Officer Aber. Marie Martinez, Building and Development Review Specialist. Annette F. Montoya, applicant, along with tenants in common, Anita Montoya, Joanna M. Anaya, Paula L. Abbott, and Anthony V. Montoya, is requesting a variance of the SLDC Chapter 8, Table 8-10, Dimensional Standards, Residential Estate, to allow one dwelling unit per 2 acres in order to split the existing 1 8-acre parcel into 4 2-acre parcels. The 8-acre property lies within the Residential Estate Zoning District. Chapter 8, Table 8-10, Dimensional Standards, Residential Estates, illustrates the allowed density at 1 dwelling unit per 2.5 acres for this zoning district. The property is located at 16 Verarda A. Tesoro within Section 9, Township 17 North, Range 9 East, Commission District 1, SDA 2, Parcel ID 9100009632. Summary. The applicant is requesting a density variance on an existing 8-acre parcel that was previously owned by the deceased Ernest Montoya, father to the applicant and the tenants in common. This variance request is being made to allow the existing 8-acre parcel to be subdivided into 4 2-acre parcels so that it may be divided equally among the 4 living siblings in Mr. Ernest Montoya's living trust. The existing 8-acre parcel is accessed through a private road and is zoned residential estates, which Chapter 8, Table 8-10, Dimensional Standards Residential E illustrates the allowed density at one dwelling unit per 2.5 acres. The applicant states that her father developed this property using his entire retirement plan. He constructed gabion walls to divert the on-site drainage, drilled and maintained a well that waters over 230 trees along roads constructed to the county's fire requirements. Since his passing in January of 2024, her 84-year-old mother currently maintains the property and has no intentions of leaving the city of Santa Fe to move to the county. This lot split allows for each sibling to have equal shares for development and maintenance. There will be a shared road maintenance agreement along with a shared well agreement amongst them. If this variance is not approved, one 3-acre lot will need to be shared by 2 siblings. The applicant has addressed the variance criteria, and staff has responded to the applicant's comments. Building and Development Services staff has reviewed this request for compliance with pertinent SLDC requirements and has found that the facts presented do not support the request for a variance. The use may impact adjacent land uses. Residential estate zoning allows for 1 dwelling unit per 2.5 acres. Recommendations. Staff recommendation is for denial of the request for a variance of density of Chapter 8, Table 8-10, Dimensional Standards, Res E, of the SLDC, which would allow 1 dwelling unit per 2 acres. If the hearing officer finds the variance criteria has been met and recommends approval of the variance, staff recommends the following conditions be imposed. Hearing Officer Hebert, may I enter these conditions into the record?
Yes, please.
This report and exhibits listed below are hereby submitted as part of the hearing record. Staff requests the hearing officer memorialize findings of fact and conclusion of law in a written recommended order. The Santa Fe County Planning Commission may be holding a public hearing on this matter on November 21st, 2024. Thank you, and at this time, I stand for any questions.
Yes, Ms. Martinez, I just saw the special warranty deed today, and I note on the warranty deed, there are 5 tenants in common.
Yes.
And I understood that there were 4 from some of the other information, that it was that there would be a division of the 8 acres into 4 pieces to accommodate each of the siblings. But there are 5 siblings, apparently, or at least there are 5 tenants in common. Is that?
Hearing Officer Hebert, so one of the tenants in common is the mother, who in the report is stated that she lives in the city of Santa Fe and does not intend to leave the city to move to the county. Therefore, the 4 siblings are requesting the density variance to be, in order to split the lot into 4 2-acre lots.
I see, okay. Is there, I think staff's report indicates that there is no any condition of the property itself that would justify this variance. Is that correct?
Hearing Officer Hebert, yes, that is correct.
And I have one question about family transfers and whether that at all would play any part in this particular situation. I'm looking at section 5.4.3.2. Does staff have any comment on whether or not the family could avail itself of the family transfer provision to avoid a variance request?
So the family transfers is allowed, but a density variance would still be required due to the minimum of one dwelling per 2.5 acres. So in order for a family transfer them to split it into 4 lots, they would still need the variance.
I see. Okay, thank you. Those are all the questions I have. Thank you very much.
Thank you.
And would the applicant come forward, please?
I do. My name is Annette Montoya. I reside at 4903 San Luis Place Northwest in Albuquerque, New Mexico. I am a native Santa Fean. I went to elementary school and high school here. So this is a property that, if you don't mind, I can read my synopsis.
No, that would be fine.
Madam Hearing Officer Haber, my name is Emma Montoya. I am representing my siblings to discuss with you this variance request to split 8 acres into 4 lots to share with four siblings, my 3 siblings. As we don't feel that a 0.5 acre per lot creates such an impact to the community, reducing it from 2.5 minimum to 2.0. My father is a true legend. He crafted many things, and this land became his career passion, as you heard before. As a young man, he provided for his mother and siblings. My father farmed this property, raised cattle on this land, and walked to the dairy on San Francisco Street before school on a daily. Being the eldest son of 9, he was the father figure to his siblings and later his nieces and nephews. Upon retirement in 1990, my father, having coffee in his usual kitchen chair, reading the Santa Fe New Mexican, came upon a legal notice that his Aunt Ursula was selling 156 acres of family property to the Joe Villa. My father, Ernest, then became an advocate to get his family property back, or at least a portion of it. He was able to obtain 35 acres of the whole 156, where he finally purchased 8 acres of the 35, while his siblings, which were underage at that time, inherited 28 acres. Here's the timeline of events that occurred. In 1990, upon my father's retirement, surrounding landowners put together what's called the Villa de Fabian Road Association bylaws, declaring the restrictions, covenants, and conditions pertaining to this 156 acres with my father's siblings, along with Mr. Garrett Quintana's signature for approval, filed in the county. In 2002, an amendment was created to these bylaws, which added the following statement: minimum lot size, no lot within the property, whether created by a subdivision, family transfer, court order, or otherwise, shall be smaller than 2.5 acres in area. This was filed in Santa Fe County on May 11th, 2002. This intent of the amendment was to control the density and the water table for future developments. In 2003, a year later, a plat was approved for my father to have the 1 8-acre parcel and his siblings 5 lots of various size in acreage. Marcy, 8 acres, Rosie, 8, Vicky, 5, Tony, 2, Gilbert, 4 acres apiece, with the remaining 1 acre to be absorbed by the roadway design layout. Let me remind you that as far as I know, no restrictions to a minimum lot size have been documented. Let me repeat myself, excuse me. Let me remind you that as far as I know, No other restrictions to minimum lot size have been documented in any amendments to this restriction, covenants, and conditions since the 2002 amendment. In 2013, across the road from this 8-acre parcel, the 28-acre parcel was divided into a family transfer, dividing 14 lots of various sizes from 1.67 to 2.1 acres in size, allowed by the county and the Villa Don Fabian Road Association. There are now 14 property owners across the road from our 8-acre parcel. Lot 1 has been recently sold, and a building permit is going to be issued very soon. My father worked very hard in keeping this 8-acre parcel, and his wishes would be to keep this land ownership to the next generation. My father did not develop this land to make money or create a subdivision, but to give his children a place to live. He was a provider. We are requesting today a 8-acre split into 2.0 acre lots, minimum size for 4 equal siblings to share. My father was reluctant to conduct this variance lot split as he had 5 children and only 3 lots. My deceased brother of 2 years' birthday is today, and he would be very proud that we are trying to move forward with this shared family development. We have grown up on this property, planting trees, maintaining weeds. There are 2 gardens that we harvest from. We have family picnics there, and we take trips to the dump on a regular to keep it clean, as it is our community space. We would like to preserve the hard work of the gabion baskets, the drainage feature, the roadway, and the beautiful environment that our family has maintained over the last 30 years. My father passed unexpectedly in January of this year. He was unable to accomplish this land split. He had a plan, but fell short to see this through. We've supported the land development and wish to keep this land within our family. In closing, although a couple of neighbors have expressed their concern about roads being overused, water table being depleted, this land variance will not be a subdivision split. We have no intentions of taking this to district court, but want to work with the neighbors as we move forward to a 2-acre minimum lot split approval. If the lot split, of course, is not approved, we will land up with 2.5, 2.5, and 3 acres, and 2 siblings will be sharing the space. In the submission, there's pictures of the property that give it no justice. I would like to invite anybody that wants to visit the property and see its magnificent beauty that my father Ernest has accomplished as his legacy. I'm hoping that the county sees that the math is real easy with 8 acres, 4 siblings, 2-acre lots. We agree with the county that only one residential property will be, one residence will be on each property, and no mother-in-law's quarters will be allowed.
Thank you, Ms. Montoya. I don't have any other questions. Did staff have any questions for Ms. Montoya?
Thank you for your time.
Thank you. Does staff have any other comments regarding this application?
Not at this time, Hearing Officer Hebert.
Is there anyone in this room who wants to make a comment on this? Yes, please come forward.
I do. Hi, my name is Thad Wadley, and I live adjacent to the property that was just described above. And first off, my sincere condolences. I knew your father, and he was cool. He was super cool, and she's right. The photos do not do justice to what he accomplished out there. So I live we share a boundary, which is sort of separated by an arroyo. And their a portion of their northern boundary is a portion of my southern boundary. I have 18 acres out there. I too was born and raised in Santa Fe. We have been out there since 1964. I have the grave sites out there that are across in the meadow, if you know where those are. And the first one is a sister that didn't make it, died in 1968. There's 4 other graves there, including my mother, my brother, my sister, and my great aunt. So I've been out there a long time. We spent over 35 years without running water, not because we were hippies. My dad would have knocked you out if he called him a hippie. We did it because there was no water out there, and we would haul our water in. It's because we didn't have electricity. That's how vacant it was out there. You needed electricity to dig a well as deep as you needed to dig it, and our well is 800 feet deep. And the driller was not happy with it because it only gave 20 gallons per minute. So my concern is, well, let me put it this way. So a variance, I believe, by definition, is granted when there's not when there's an inconvenience, but when there's some sort of inconsistent ruling to an existing law. So the existing law is 2.5 acres is the minimum. And that was, as I understand it, and I think wisely done, mainly because of water, but also because of density. When we bought our property, the gentleman we bought it from, Mr. Trujillo, he based our land value on the Spanish land value. How many sheep would it raise? He determined it wouldn't support more than 2. So he said that at the time, it was literally his most worthless property he had. That was a long time ago, and my mom said, yeah, but look at the view. And I don't want to become a, not in my backyard, but the truth is, I believe that for most of that time until the 2001, we did what we thought was going to be a family land split in the 80s into 5-acre parcels. Because I had a brother and sister, both who had passed away. And that at the time was where the county was heading, was going to be the minimum amount. And then, as stated in 2001, that was updated to 2.5-acre parcels. So the property out there, in my opinion, is dense enough already. And I respect what your father did very much, but I also request that the existing ordinance be honored, because I don't see, there's no outstanding reason to do it otherwise, really. And a variance, in my opinion, should be extenuating circumstances, not because, and also I think that per their wishes, and probably per their father's wishes, I think it will stay in the family. I hope it does. I really does, because what I've seen out there consistently, the people who live out there for a long time, including my family and the Jacksons, who still have 80 acres over on Fin del Sendero, they don't split their land. They don't split their land because they don't want it. They're not in it for the money, just like your father was not in it for the money, and I agree with that completely. They keep it they try to keep it in the family. So I do hope that you keep it in the family, but I also hope that the county rejects the variance request and keeps it at a 2.5-acre minimum. And I do hope that there's a way for them to satisfy that there are 4 applicants for three lots.
Thank you, Mr. Wadley.
Did I give my address? My address is 88 Uvilla Doro in Santa Fe, New Mexico, 87506. Thank you.
Thank you. Are there any other comments on this application? Yes. I can't hear you.
We had submitted a written comment and wasn't sure if it was on record.
All right, I believe I have a couple of comments here. I have, are you Dr. Ivan Apollondi?
No, John Wolf, how
All
about?
right, are you John Wolf?
Yes.
All right, yes, I do have that comment.
I
Thank
had a
you.
letter too from our road association treasurer. She wasn't sure if it was going to get here on time. She is
All right.
very chowning.
No, I don't have that. If you would give that to staff, and maybe they could make a copy for the court reporter and for me.
And Hearing Officer Aber, this is the one letter of opposition that came in yesterday that was added to the agenda. But I have a hard copy here for you.
All right, thank you.
I don't have anything to add to our written statement. I just wanted to make sure it was on record.
Thank you. Okay. Are there any other comments from, yes, Ms. Doria?
And then here in Al Saber, we have two people online that are wishing to speak.
I just wanted to reiterate that across the road, the county did approve in 2013 a 14 lot split. So 14 homes are going to go in across the road from here, from 1.67 acres to 2.1 acres. So we don't feel that we are changing the density to the greater extent. This was something that the county approved back in 2013. This is also part of the Montoya Trust. They just did it in 2013.
But nothing's been, it was platted then, but then there's been no development, is that the situation?
Yes, there's one property owner that has sold outside the family, and they're getting ready for building permit right now. So it's a subdivision.
Thank you.
Thank you.
If we'll go to the online.
Here in Al Saber, we have a Craig Friedman, who was the first one to raise his hand to speak.
Good afternoon. This is Craig Friedman. Are you able to hear me?
Yes, I am. Just a moment. The court reporter will swear you in.
Mr. Friedman, do you swear or affirm the testimony you're about to
Yes.
give is the whole truth? And please give your name and address.
I do. Craig Friedman, 51 Paseo de Antelope. I'm here today to comment on this variance request. I am opposed to it, the density variance, as I believe it's not in the best interest of parcel holders, and it does violate the amended declaration of restrictions and covenants and conditions dated March 2002, which govern the area. I have resided in the area since 2007, and I currently serve as the Villa Don Fabian Road Management Association president. And I feel that this is not in the best interest of the area. I do have utmost regard and respect for our lost neighbor, Ernest Montoya, and his family. However, I don't think that utilizing variances to minimum sizes to deal with trust and estate issues is appropriate. Thank you.
Mr. Friedman, could I just ask you about this 2002 covenants? What was that, a declaration filed with the county?
Yes. I believe under state land use at that time, they had to create this covenants for the development of the lands that traverse the Paseo de Antelope, Paseo de Coyote, and the other extensions back, and that's what this was created, and I believe it was for compliance within state law as it related to communities. But I am not a land use expert in New Mexico.
Okay, thank you. Are there any other comments?
Hearing officer, we have a Krista Vessel and an Ivan that wish to speak.
Crystal?
Yes, I'm Krista Vessel, and this is Ivan Papalitti. Thank you, Madam Hearing Officer Aber, for hearing us today.
Yes, and I
Krista,
do
can I
have-
swear you in?
oh, okay.
Are you both going to speak?
Yes,
Please raise your right hand. You swear or affirm the testimony you're about to give is the whole truth.
I do.
I do.
And before you speak, please state your name and address for the record.
Krista Vessel,
Dr. Ivan Papalitti, address is 14 Paseo del Prado, Santa Fe, New Mexico, 87506.
And just so you know, I do have your letter dated September 27th. But please, continue.
thank you. As we stated in our letter, we are concerned about many things that add into the beautiful Santa Fe area, the reason why we came to live here. We appreciate the density restrictions and the value of water and our road system. We do not have paved roads in our neighborhood. We have gravel roads that we have to maintain through an association. And we have benefited from our relationship with Ernesto Montoya over the years. He was very friendly with us. We received a lot of his produce from the garden, and we often spoke together about the wonder of the land that we lived on. He had expressed to us that he didn't want to develop the land. He appreciated having his trees, his gardens, and his view. I would like to point out that the 14 lots that were split into smaller parcels, that was a family split. So that was not something that was done in the interest of the community. That was done for the family. And we don't see anything in this split to 4 lots instead of 3 that would make it in the interest of our community, and that is why we are opposed.
And while it may represent an inconvenience to the family to do a split in the way that is legal at the current time, that doesn't really meet the standard of a hardship. The use of the property under the current standards and zoning does not adversely affect the current owners except by convenience. And they can, as a tight family, organize that amongst themselves without impacting the community that surrounds them, in our opinion. The family splits that took place as was explained earlier, across the street of the total 38-acre parcel, down to acreages as small as 1.67 as family splits, that happened. We didn't know about it until after we had bought our property. And once we became aware of it, we were deeply concerned that it would turn into a development in a community that is not, that is sparsely developed as it is right now, where everybody is held to the 2.5 acre standard. It doesn't make sense that we would allow anyone else to split less than what we already have to do ourselves.
Could I ask, I know someone testified to it, but when was this 14 lot split? When was that? The 38 acre split? Do you know?
Do you know?
Hearing Officer Aber, so the land use administrator for Santa Fe County actually signed off on that in 2015.
2015, okay, thank you. Do you have any other comments?
That is all that we have today. Thank you so much.
Thank you.
I actually do have comments. I raised my hand, but it didn't look like, but it was acknowledged.
I'm sorry, I missed that. Would you repeat that?
Hearing Officer Abear, we have somebody else, an Anthony Montoya, who has raised their hand and wishes to speak.
All right, thank you.
Mr.
I
Montoya?
assume I need to be sworn in first? Yes.
I need to swear you in. Do you swear affirm the testimony you're about to give is the whole
Okay.
truth?
Yes, I
State your
do.
name and address for the record.
My name is Anthony Montoya. I live at 3385 South Ash Street in Denver, Colorado, 80222. And I'm one of Annette's siblings and one of the siblings in question for the family lot split. I want to make a few comments. First of all, my father did do a lot of work out there, and he was always very clear in any conversations he had with the neighbors that his intent was to leave the property to his children. As my sister stated, we had 5 total. Now we have 4, which would have, if he were alive, enabled the lot split to be able to go forward with the 4 of us. The family lot split, when created in New Mexico and Santa Fe, was always for this intention specifically, for families that had property that wanted to leave it to their families and so it wouldn't be sold, and so that I hate to use the term outsiders, but non-natives could move, buy the homes, and essentially push out folks that were local that couldn't afford to build in some of these properties. So that was one of the original intentions of the family lot split. We're following that guidance and have always been very clear to it ourselves. As far as the association goes, if I were in the association, I would say, hey, this is great. We have more lots. We have more ways to spread the cost of the road maintenance, and maybe even do improvements to the road. I do participate in the association meetings from time to time. I know that financing is always a challenge. And so in my mind, it would seem like having, instead of 1 lot, which is the way it is right now, having 4 lots, that would mean additional funding for the upkeep and maintenance of the road. So I think that's something that should be considered. Lastly, when the other lots were split into 14 lots, at that time there was not a requirement, at least as far as I know, there was not a requirement for a variance restriction. That is something new, and it's, had that not been there, we would have moved forward with our family lot transfer and hopefully not had to have gone this route. But because the requirement's there now, we're going that way. And then lastly, I will say that my father, I don't want to repeat the work he's done out there, but one of the things he did was when he dug his well, he ensured that the well was going to be adequate for a lot split down the road. The lot, I don't know if they've spoken to the well there, but the well has ample capacity and ample pressure to be able to support 4 properties, so that it should not be as much a burden as some of the others are claiming. And then lastly, again, as my sister stated, going from a 3 or a 2.5 acre to a 2 acre lot is not going to be a significant impact to any of the environment or anything else out there, in my opinion. That's all I have. If you have any questions of me, I'd be more than happy to answer them.
Thank you, Mr. Montoya. Is there anyone else that wants to make a comment? Oh, just a moment. Is there anyone else online that wants to?
Hearing Officer Abear, there's nobody else indicating they wish to speak.
All right. Mr. Wadley, did you want to add?
Hi, Thad Wadley again. And I didn't bring this up because it was already talked about, but I would like to, just going back to the water again. So if this subdivision that happened across the street, whether it was family or not, if it was in 2015, there was a huge outcry in the Northwest Quadrant in 2016, 2017, largely because of the deep well from the city. And it was starting to deplete wells left and right. So one of the things that I did bring, and I can give it to your thing here, but I'll just show it to you briefly. And you can see so this is a monitoring well. It's the closest one to these properties that we're talking about. And the indication's there's not a huge amount, but you can see the way the graph is going. And this is from 2019 to current, January 20, sorry, this is right here. This is July 24. So it is still going down. And that's completely controllable because the outcry that happened that implemented this monitoring, the city stopped taking as much water. So now they are capped at, I believe, 650 acre feet a year. Don't
And
quote me on
excuse me, is that a chart related to the city well?
This is a monitored city well that is located, if you can see it from here, here's the corner we're talking about. This is the Santa Fe land grant. This little box right here is the property that is in, the variance is being requested for. The nearest monitoring well, which is the one that this graph is for, is located 73001. So it's probably a mile away, but it's the nearest one I could find.
From the property, your property
Exactly.
and the applicant's property?
Yeah.
All right.
All these wells out here that are also monitoring wells out in the La Tierra area, they're dropping. And I don't want to, I'm not here to be drastic about this. They're not dropping precipitously, but the reason they're not dropping is because the city agreed to stop taking as much water from the 2,000-foot deep well. So every time, I know everybody keeps saying it's like, it's not this big difference between 2 acres and 2.5 acres. But the truth of the matter is I do see what this area is. And the satellite photo, or the photo that does not do the property justice, if you have 4 properties and 4 houses there instead of 3, it does make a big difference. And I would venture to believe that if the outcry from the Northwest Quadrant had happened pre the time when this other big lot split happened, which I've been aware of, but I didn't know how I didn't know it was 14 different lots. I believe wholeheartedly that it would have been denied.
I see.
Because water is a real issue out there.
Mhm.
So that's all I wanted to add.
Okay, thank you, I appreciate it. Could we get a copy of that chart?
Oh, yeah.
Hearing Officer Abear, we have 2 people have re-raised their hands wishing to speak.
Okay. All right. Are these people?
The same people. Mr. Montoya was the first one to raise his hand.
All right, Mr. Montoya, please continue. Thank you.
Yes, Madam Hearing Officer, I'm assuming that I'm still sworn in. By that same argument they present on the well, it would also say that there should not be any affordable housing built in Santa Fe, because that same well is going to monitor areas where they are considering doing larger builds, higher density build out. So by that same argument, you shouldn't build anything in Santa Fe. Second of all, relative to the comments that have been presented here, if I owned a home out there in the proximity of my father's home, it's beautiful. It's 8 acres. It's fenced in. There's a garden. There's bike trails near it. It's a beautiful property. If I owned a house by there, I'd say I'd rather keep it 8 acres open because, it gives me more something to go out and look at. So I'd fight the development of it just as well. So not to discount their comments, but you have to consider that they, having a neighbor that's at 8 acres undeveloped, who wouldn't want that next to their house? What we're saying is that this is something that needs to stay in our family, will stay in our family. We would like the right to develop it as siblings, as the family lot transfer allows. And, I live in Colorado. My plan is to retire and be back in Santa Fe. I love Santa Fe. I always have. I still have family there, and I'm sure my siblings feel the same way. So I think when you look at their arguments, you have to consider that, the value of their property sitting across the street from something that's undeveloped and it's beautiful. I can't blame them, but you can't use that as consideration for denying a lot split, a family transfer lot split. Thank you.
Thank you, Mr. Montoya. Is there another person?
Hearing Officer Abear, they lowered their hand.
They did, okay, all right. So is anyone else in this room wanting to make a comment? So I don't see anyone, and I will issue a recommended order on this requested variance within 15 business days, and thank you all for your attendance. And with that, I will adjourn this meeting.